Let us
Please be seated. The sitting is open. The court meets today and will meet in the next 3 weeks to hear the oral argument of the parties on the merits in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia versus Myanmar, 11 states intervening. I note initially that Judge Okowa has recused herself from the case under Article 17, Paragraph 2, and Article 24, Paragraph 1 of the Statute of the Court, and that Judge Bandari is unable to participate in these proceedings for personal reasons. I also note that for reasons duly made known to me, Judge Shue is unable to take her seat on the bench today and for some time in the coming days. Since the court does not include upon the bench a judge of the nationality of either of the parties, both parties have availed themselves of the right under Article 31, Paragraph 3 of the statute to choose a judge ad hoc. The Gambia chose Ms. Davenida Mpile and Myanmar Mr. Klaus Kress. They were duly installed as judges ad hoc on the 10th of December 2019 during the phase of the present case that was devoted to the request for the indication of provisional measures submitted by the Gambia. I shall now recall the principal steps of the procedure in the present case. On the 11th of November 2019, the Gambia filed in the registry of the court an application instituting proceedings against Myanmar concerning alleged violations of the Convention on the Prevention and Punishment of the Crime of Genocide, adopted by the General Assembly of the United Nations on the 9th of December 1948, to which I shall refer as the Genocide Convention or the Convention. In its application, the Gambia sought to base the jurisdiction of the court on Article 9 of the Genocide Convention in conjunction with Article 36, Paragraph 1 of the Statute of the Court. The application contained a request for the indication of provisional measures by an order dated the 23rd of January 2020. Having heard the parties, the court indicated certain provisional measures addressed to Myanmar. Time limits were subsequently fixed and then extended for the first round of written pleadings. The Gambia filed its memorial on the 23rd of October 2020. Myanmar, for its part, on the 20th of January 2021, raised certain preliminary objections to the jurisdiction of the court and the admissibility of the application. By a judgment of the 22nd of July 2022, the court found that it had jurisdiction on the basis of Article 9 of the Genocide Convention to entertain the application filed by the Gambia, and that the said application was admissible. Myanmar filed its counter-memorial on the 24th of August 2023 within the new time limit set for that purpose. By an order of the 16th of October 2023, the court authorized the submission of a reply by the Gambia and the rejoinder by Myanmar. The Gambia filed its reply on the 23rd of May 2024, and Myanmar filed its rejoinder on the 30th of December 2024. After the closure of the written proceedings, both parties requested authorization to submit new documents pursuant to Article 56, Paragraph 1 of the Rules of Court. On the 8th of September 2025, Myanmar sought the admission of 3 new documents. Taking into account the lack of objection by the Gambia, these documents were added to the case file. For its part, the Gambia presented several requests to submit new documents. The court authorized the production of some of these documents, which were added to the case file. Pursuant to Article 56, Paragraph 3 of the Rules of Court, Myanmar commented in writing on the new documents admitted and submitted documents in support of its comments. I shall now say a few words about the proceedings related to the declarations of intervention in the case. On the 15th of November 2023, the Maldives filed a declaration of intervention in the case, with reference to Article 63 of the Statute of the Court. On the same date, a joint declaration of intervention was filed, pursuant to the same provision, by Canada, the Kingdom of Denmark, the French Republic, the Federal Republic of Germany, the Kingdom of the Netherlands, and the United Kingdom of Great Britain and Northern Ireland, to which I shall refer as the joint declarants. By an order of the 3rd of July 2024, the Court decided that the declarations of intervention submitted by Maldives and the joint declarants were admissible, insofar as they concern the construction of the provisions of the Genocide Convention. On the 28th of February and the 3rd of March 2025, the Maldives and the joint declarants, respectively, filed written observations on the subject matter of their interventions pursuant to Article 86, Part 1 of the Rules of Court. Declarations of intervention under Article 63 of the Statute of the Court were also filed by Slovenia on the 29th of November 2024, the Democratic Republic of Congo, to which I shall refer as the DRC, on the 10th of December 2024, Belgium on the 12th of December 2024, and Ireland on the 20th of December 2024. By an order of the 25th of July 2025, the Court decided that the declarations of intervention submitted by Slovenia, the DRC, Belgium, and Ireland were admissible, insofar as they concern the construction of provisions of the Genocide Convention. The DRC, Slovenia, Belgium, and Ireland filed written observations on the subject matter of their intervention under Article 86, Part 1 of the Rules of Court on the 22nd, 23rd, the 24th, and the 25th of September 2025, respectively. By letters dated the 17th and the 21st of October 2025, the parties and the intervening states were informed that the court considered that it had been sufficiently informed of the position of the intervening states on the subject matter of the intervention by way of written observations, and that it did not deem it necessary for them to submit observations in the course of the oral proceedings in accordance with Article 86, Paragraph 2 of the Rules of Court. I shall now address the organization of the oral proceedings, in particular with respect to the presentation of the evidence. By letters dated the 17th of July 2025, the registrar informed the parties of the date fixed by the court for the opening of the hearings on the merit of the case and asked them to provide by the 8th of September 2025 the names of any witnesses and experts they intended to call during the oral proceedings, as well as other information required by Article 57 of the Rules of Court. The parties communicated to the registry, within the time limit fixed, information concerning the witnesses and experts that they intended to call at the hearings. The Gambia indicated that it wished to call witnesses and an expert, whereas Myanmar stated that it intended to call only witnesses. By letters dated the 17th of October 2025, the registrar informed the parties of decision taken by the court in relation to the hearing of the witnesses and expert during the oral proceedings. The parties were in particular informed that the court had decided that the parties' witnesses and the expert to be called by the Gambia would be heard in the order requested by each party. The parties were required to submit by the 18th of November 2025 a written affidavit for each of the individuals they intended to call as a witness at the hearings. The Gambia was also required to submit a written statement by the expert it intended to call to testify. The parties were also requested to provide, by the same deadline of the 18th of November 2025, unredacted copies of any previous statements or accounts given by the witnesses or expert called to testify during the oral proceedings, which have been annexed to their pleadings in redacted form. The letters underscored that the unredacted version of the affidavits, written statement of the expert, and prior statements or accounts provided by each party would be communicated to the judges and the other party, but would be treated as confidential and would not be made public, available to the public. By letters dated the 13th of November 2025, the Deputy Registrar informed the parties of further decision taken by the court concerning the procedure for examining the witnesses and the expert called by them. The parties were thus advised that after making the solemn declaration provided for in Article 64A of the Rules of Court, each witness would be asked to confirm his or her written affidavit, and if applicable, any prior written statements or accounts annexed to the written pleadings, subject to any correction the witness may wish to make. The calling party would then proceed to its direct examination, which would take the form of replies by the relevant witness to questions put to him or her by counsel. This would be followed by cross-examination of the witness by the other party, which would be confined in scope to written and oral statements already made as part of the witness evidence in chief. A re-examination by the calling party would then be possible, limited to matters having arisen as part of the cross-examination. The expert called by the Gambia would be asked, after making the appropriate declaration in accordance with Article 64B of the Rules of Court, to endorse his written statement as well as his earlier reports annexed to the Gambia's written pleadings, subject to any correction the expert may wish to make. The written statement and reports would constitute the expert's evidence in chief and serve in lieu of his direct examination at the hearings. This would be followed by cross-examination of the expert by Myanmar, which would be confined in scope to statements already made by him as part of his written statement or reports, and re-examination by the Gambia, which would in turn be confined to matters arising as part of the cross-examination. Following re-examination, question could be put to the relevant witness or expert by the President on behalf of the court or by individual judges. The witnesses and expert would respond orally and without delay to any question put by the parties or by the judges, except in particular circumstances, for example, when specific information was requested that needed to be verified. In order to ensure the safety of the witnesses called by the parties, the court decided that they would be heard in closed sessions, with only judges, registry staff, interpreters, technical personnel, and members of the delegation on the official list provided by each party to the court being allowed in the courtroom during the in-camera sessions. The parties were also informed that the court had agreed to the use of pseudonyms when addressing the witnesses called by the parties or when referring to them at the hearings. By a letter dated the 18th of November 2025, the Gambia provided written affidavits of its witnesses as well as the written statement of its expert. By a letter of the same day, Myanmar informed the court that it intended to call only one witness and reserved the right to call a different witness if for any reason the former should be unavailable to testify. Myanmar also provided confidential written affidavits for both of these witnesses in the Myanmar language, accompanied by certified translations into English. It further indicated the pseudonyms that should be used for these two witnesses. After ascertaining the views of the parties, the court decided, pursuant to Article 53, Paragraph 2 of its rules, that copies of the pleadings and documents annexed in their redacted versions as appropriate will be made accessible to the public on the opening of the oral proceedings, except for certain annexes that would be kept confidential. In addition, with regard to written pleadings and documents annexed, which contain written statements and accounts given by the witness called by the parties, as well as the redacted version of the affidavit of witnesses and the verbatim record of their testimonies, it was decided that these materials would only be posted on the court website after the end of the oral proceedings. The court also decided to make accessible to the public, on the opening of the oral proceedings, the reports submitted by Myanmar on the measures taken pursuant to subparagraph 4 of the operative clause of the order on provisional measures of the 23rd of January 2020 and the Gambia's comments on them. In this respect, the Court notes that the parties were consulted on this matter and did not object to such publication. Further, after consulting the parties and the intervening states, the Court decided to make accessible to the public, on the opening of the oral proceedings, the written observations of the parties on the declarations of intervention pursuant to Article 83, Paragraph 1 of the Rules of Court, the written observations of the states seeking to intervene, and those of the parties on the admissibility of the declaration of intervention in accordance with Article 84, Paragraph 2 of the Rules of Court, as well as the written observations of the intervening states referred to in Article 86, Paragraph 1 of the Rules of Court on the subject matter of their intervention. I note the presence in the Court of the agents and counsel of the two parties. In accordance with the arrangement for the organization of the proceedings, which have been decided by the Court, the hearings will comprise a first and second round of oral argument. The first round will begin today with the oral pleadings of the Gambia and will close on Tuesday, the 20th of January 2026, following Myanmar's first round of pleadings. For the first round, each party will have 6 sessions of 3 hours at its disposal. The second round of oral argument will begin on Monday, the 26th of January, and conclude on Thursday, the 29th of January. Each party will have 3 sessions of 3 hours to present its reply. In addition, the Court will hear witnesses and experts between the 2 rounds of oral argument. The witnesses of the Gambia will be heard in 3 closed sessions on the morning and afternoon of Wednesday, the 21st of January, and on the morning of Thursday, the 22nd of January. The expert called by the Gambia will be heard in open session on Thursday, the 22nd of January at 3 p.m. The witness called by Myanmar will be heard in closed session on the morning of Friday, the 23rd of January, 2026. In this first setting, the Gambia may, if required, avail itself of a short extension of time in view of the time taken up by my introductory words. I now give the floor to the agent of the Gambia, High Excellency Mr. Dawda Jallow. Sir, you have the floor.